Yes, Mr. Day.
My Lord, before picking up where I left off, can I just deal with 3 points that arose during the course of submissions this morning?
Yes.
The first is the long stop. I should say some papers have been handed up. I hope are...
I've got a clip with the letter of the 7th of December 2022 on the top.
There are 3 documents in there. I'll just
Right.
take you through them. I've given copies to my learned friend.
Yeah.
But the first document that I wanted to address briefly was the document headed Contract for the Sale of Property by a Trustee in Bankruptcy.
Yes.
And this is just to briefly address the point about long stop dates.
Yep.
Because I think the submissions made in the eviction proceedings on that weren't developed, and I just want to make the position clear, at least as to what appears on the page. Questions of interpretation can wait for another day.
Right.
The so-called long stop date appears on page 4 of this contract. And you'll see a definition of contract period, which is 24 months commencing on the date of this contract.
And that was the 15th of January 2019.
Correct. So we're outside that. And the
Yep.
way, sorry, my lord, the way that definition is used appears on page 8.
8.
Clause 12.6, and it provides in the event that completion has not occurred by the end of the contract period, the trustee and or buyer will have the option to waive the conditions precedent and complete the transfer of all rights, title and interest received by the trustee under the deed of assignment. That's referring back to the back-to-back sale from the liquidators.
Yes.
I don't want to go further than that now, but just so it's clear as to what we mean when we're referring to a long stop date. It's not, the contract doesn't fall away, it's a deadline for certain conditions precedent to be completed. And if they're not completed, then the question of waiver arises. One of those conditions was the application by Mr. Swift to clean the title, as it were, on the register. So that's the first document. The second is, I can take briefly, is a judgment that will look familiar to my Lord Justice Arnold, which is the Airways Pension Scheme Trustee case.
Yeah.
I'm not going to make submissions on this, but I'm just going to draw the court's attention to the relevant passages since it's been raised. And the relevant section begins on page 13 of the judgment. See a heading, Costs, Orders, Following Appeals. Just above paragraph 51.
Page 13, yes.
Yeah, page 13. And then re Londonderry is then picked up at paragraph 54 on the next page. And my Lord Justice Arnold discusses that case at paragraphs 54 and 55. Then discusses...
Yes, and the point that's worth picking up from 55, which I've forgotten, is that not only did the Court of Appeal allow the appeal, they ordered the costs of the trustees to be paid out of the trust funds.
Lord, yes. And
whereas if it was in any way improper, that order would not have been made.
well, as my Lord says, the court didn't give reasons for making that order, so there may be a limit to how far that fact can be taken in understanding the expression of principle in the majority judgments about what they describe as procedural.
But then the next case that's discussed is a Guernsey Court of Appeal decision, which preferred the minority.
My Lord, exactly right. I was just going on to that, and in fact, this Guernsey decision is footnoted in the passage in Underhill and Hayton to which I took the court this morning. And my Lord's discussion, or conclusion, if I can put it that way, is at paragraph 59, page 15, where my Lord accepts that it's technically correct that the Guernsey decision does not represent English law. But he says my Lord says it's persuasive authority, and even if it's disregarded, it doesn't seem to me that the English authorities establish any inflexible rule with regard to trustees' appeals. So that doesn't rule out the Londonderry principle. It suggests it may be a slightly more open-textured test than the test I put forward this morning. I maintain my submissions from this morning, but I'm not going to repeat them now. But that's just so that case is before court.
That's very helpful, thank you.
And then finally, there is a clip of correspondence beginning on the 7th of December 2022. And this is an answer to my Lord Justice Lewison's question right at the beginning. Why hasn't there been a sale?
So what are we looking at? 20th of December 22?
7th of December. It's a clip of correspondence. It begins on the 7th of December 2022.
Yes.
I should say there is a WP sales to cost letter which precedes this. We think the privilege over that has been waived, but since my learned friend hasn't had time to consider that, I'm not going to take you to that letter until he's considered that properly. So I'm just going to deal with the open correspondence. But if I can take you within the 7th of December letter to paragraph 6. Paragraph 6 sets out 3 options that are available to the trustees. The third option is your clients agree to transfer such interest as they have in the cottage to Chedington, so the sale. And then paragraph 7 develops on that. There was no response to that letter. One then goes to the next letter, which begins at page 4 of this clip. 14th of December. And you'll see again, it refers back to the previous correspondence. It says, we propose that the trustees transfer such interest as they have in the cottage to Chedington. We received no response to either letter. Had you agreed to our proposal, it would have extricated your clients from the ongoing litigation and thereby avoided, etc., etc. That was before, I should say, so far, this is all before the trustees, it postdates the application, but predates the deadline for joinder, if I can put it that way. The WP letter, which, if I can show you, I will, predates the application itself. So the beginning of this correspondence begins before the application. The 2 letters I've just shown you.
So you didn't amend your application to ask for an order that the trustees sell you the cottage, did you?
I'm sorry, my lord, I didn't catch the question.
You didn't amend your application, did you, to ask for an order that the trustees sell you either the cottage or the bare cause of action?
My lord, no. I've just, it's an answer to the factual question, if I can put it that way.
All right.
And it does provide some context.
Yes.
So that's the 14th, and then no response to the 14th letter. Then there's a third letter from Stewart's on the 6th of January. That's 3 days after the joinder application has been filed at the Court of Appeal. And it refers back to the previous 3 letters and makes the point again, had the trustees accepted any of those offers, they would have avoided the ongoing litigation, etc., etc. I won't take the court through all of it, but the whole of that letter is worth reading at some point. Page 2 of that letter, page 6 in the clip, at the top repeats the offer to take an assignment. And then the first response to that line of correspondence comes on the 10th of January, so a couple of months after the offer had initially been made. My lord will see at paragraph 6, it says the trustees are agreeable in principle to entering into an assignment, subject to a number of points. One of those points which is just worth noting, given the wider context of the appeal, is 6.2, where the trustees say that they understand that the cottage has increased in value since the swift sale. Chedington would need to acknowledge that in those circumstances, because the trustees will be bound to realise the cottage to maximise realisations for the bankruptcy estates. Stewart's then respond at page 9 of the tab. And by this point, not only had the joinder application happened, but the trustees had appealed and had permission to appeal accepted, given, to put it that way, against the original directions. And so the proposal then made by Chedington is that the assignment be contingent on whichever one of the following events occurs first. First, the trustees are successful in this appeal, so if this court is not with you, or alternatively the trustees are successful in their application for possession of the cottage. And then we ask for a response. That response doesn't come until April, so about a month later. Page 11 of the tab. And at the foot of that letter it says, we confirm that our clients remain open to sensible discussions. However, in your letter, dated the 3rd of March, you seem to recognise that detailed discussions would be better left until the eviction appeal application is resolved in one form or another. And we would consider that it is the best approach unless you perform it. That's the end of the clip. So I hope that assists in the question that was asked.
Just remind me, would you, what is the date of the judge's judgment in this case?
The
25th November.
Yes, but the decision was announced prior to that.
So this correspondence starts after the judgment is given.
Other than the WP,
Yes.
which if I can show you, WP service to costs, I will. Because that obviously has a bearing.
So the judge then wasn't asked to consider as an alternative directing a sale either of whatever interest the trustees had in the cottage or the cause of action.
He wasn't asked. The only correspondence, as at the date of the hearing of the
It
application,
was all about the
was,
trustees actually making an application themselves.
well, that in open correspondence.
Yeah. No, I follow.
But there was a WP letter.
Well, I'm not interested in the WP letter.
Well, I hope you might be if I could show it to you, but there we are. Those were just 3 points I wanted to pick up from this morning. Can I now resume? I was in my
Yes.
second heading, and I was dealing with the judge's finding that the trustees were striving at all costs to avoid taking the sides against the bankrupts, and the material that justified the judge in reaching that finding. I showed court just before the short adjournment the letter of the 3rd of November. I can now show you the response from the trustees to that letter. That's in the supplementary bundle, tab 16. Page 158. Now, at this stage, the trustees could no longer maintain their position as at the 28th of October. That intervention would necessarily be at a cost to the estate and with no possibility of a return to the estate. Both of those points we say have been removed by the terms of the 3rd of November proposal. And so this letter put forward 3 entirely new justifications for refusing to intervene. And we say there are 3 important errors in this letter. The first is in the first paragraph, where the trustees appear to be proceeding on the misapprehension that the proposed application was being made by Chedington alone as a non-creditor. And that wasn't the case. The first and second respondents to this appeal are the majority creditors in the bankruptcy.
Yeah.
The second error was that the trustees appeared to consider that the question of whether or not they were the beneficial owners of the cottage turned on the validity of a contract between Mr. Swift and Chedington. And that was also an error because, as discussed this morning, the question of beneficial ownership now is contingent on, well, determined by the contract with the liquidators, between the liquidators and the trustee in bankruptcy, not the trustees in bankruptcy in Chedington. There may be nothing in that, but it certainly shows a lack of understanding at this point. And the third error, which is important, is that the trustees claim here, and that's the third paragraph, that the equity in the cottage would not be available to the trustees in bankruptcy on a sale to Chedington because of the charging order which Patley Wood Farm held over the cottage. And again, that was wrong because Mrs. Bream had agreed to remove that charge as part of the sale to Chedington and had told the trustees as much, or reminded them, in her letter of the 21st of October 2022. For your notes, that letter is in the supplementary bundle at tab 10, page 148. And that point is important when we come to the hired gun cases, which I'll come on to in due course. Over the page then, 159, second paragraph, it said in those circumstances the application is precipitous, and we can confirm that our intention is to write to the Court of Appeal by the relevant date to confirm that the trustees intend to maintain their neutral position in respect to the eviction proceeding and will not be making an application to be joined. And that's important because taking this letter at face value, and this was the submission that I made to the judge below as well, the 3 reasons given by the trustees for reaching their decision are the 3 reasons given on the first page, and each of them is mistaken. Now, it is true that having said in the circumstances they're not going to apply, they then raise 2 other points for completeness. The first is the offer of funding and indemnity. That's point 1, towards the middle of page 159. And that was said to be inappropriate because of the trustees' need to maintain neutrality between the Briggs and Chedington. That point has evolved considerably since that letter, because now the point is all framed around officeholder independence. Now, my learned friend may say that the trustees mixed up their language and meant to talk about independence rather than neutrality below. But even if that were the case, and we don't accept it for reasons that I'll come on to, there's no explanation in this letter as to how third-party funding per se would threaten their independence. It's just a bare assertion. And moreover, and I've made this point already, it wasn't stated to be the reason for refusing to intervene. It's dealt with here as a point for completeness. And then the second point made at the very end of the letter is on the offer of £3,000.
Yeah, that was dealt with by the option rather than the obligation.
That wasn't opposed. It went by consent. The hearing below, so there's really nothing in that point at all. By the time of the hearing below, the trustees' reasons for opposing the directions had evolved yet further. And if I could do this briefly by reference to the skeleton argument of the trustees below, that's in the supplementary bundle at tab 1. And the relevant passage begins on page 10.
On page 10.
Page 10, paragraph 16.
Yes.
And the court may recognise it because it's quoted at some length in the judgment below. You see the heading, the reasons for the trustees' decision not to join the eviction proceedings. And if you jump over the page to page 13, you see at paragraph 16e, at the end of the paragraph, the confirmation that these are the reasons for refusing the proposal being put forward by all 3 respondents, as at the 9th of November, even though they were not the same as the reasons that were actually communicated to the respondents on the 9th of November. And that was a point made below and the point which we say the judge accepted and was entitled to accept. Now, just dealing very briefly with the sub-paragraphs of paragraph 16. Paragraph 16a makes the point that the trustees weren't ordered. There's a question of if so advised. That obviously took the issue nowhere, because the issue for the court below was not whether it was a decision for them, that was common ground. The question was whether that decision was perverse, so that didn't take the application anywhere. Paragraph 16b then refers to various risks of costs and expenses. And those were all dealt with by a letter from Stewart's that appears at tab 32 of the bundle, supplementary bundle I should say. We can just jump there briefly.
Is that tab, big one?
Sorry.
I missed the cross-reference, I was just reading that.
The cross-reference is tab 32 of the same bundle, page 180. And the court will see that in the middle of the page, paragraph 16b of the skeleton argument is addressed, and each of the points made in paragraph 16b were addressed in full. And then over the page 181, the point is made in the middle that if the trustees continue to oppose the application, it becomes even more obvious that the matters raised in paragraph 16b of your skeleton argument were not an Arnold the reasons the trustees actually have for not joining the eviction proceedings. The trustees refused to agree then to take a neutral stance, and that was the letter that I showed the court this morning in the context of making my submissions on the Londonderry principle.
So, number paragraph 1 in that letter is an allegation of duplicity, yes?
It's an allegation that we don't accept that the submission being made at paragraph 16b of the skeleton argument constitutes the real reasons for refusing to participate. And it was was on the basis of this letter, amongst other things.
So it's an allegation of duplicity.
I wouldn't go so far as to say it's an allegation of duplicity. I'd say it's a retrospective reason for a decision already made, because the trustee's starting point was...
That's not what paragraph 1 says. It's saying that the actual reasons are different.
My lord, I can see the point with the word actual. Let me put it another way.
Not the reasons the trustees actually have. So that's an allegation that there are real reasons that the trustees have which are different to those that are put forward on their behalf.
My lord, yes, that's what's said in the letter. And it was on the basis of this letter, amongst other things, that I made submissions to the judge which resulted in the finding in paragraph 50 of the judgment that the overriding concern of the trustees was to avoid litigation at all costs with the breaks. I don't think, to be fair to the judge, that he went as far in his judgment as this letter goes in terms of actual reasons. But I accept that the words on the page say what they
Yeah.
So that's paragraph 16b. Just going back very briefly to the skeleton argument from below, back in tab 1 of the same bundle, page 12. Subparagraph C.
Well, you say that's subparagraph B. It isn't actually. Roman 1 you may have dealt with. Roman 2 you may have dealt with.
Yes.
Roman 3 you hadn't. And there is a challenge to the application for joinder. Roman 4, risk of challenges to be made by breaks to any decision by the trustees. That's not an irrational fear, given what the history of this matter. Non-legal expenses and time are being incurred, including office holder time. You say that's illegitimate because they're not entitled to have regard to that.
My lord, can I take you briefly back to tab 32, page 180, to see what we say about those matters?
Yeah.
So, what 1 and 2 we've discussed. Paragraph 16b3, we say Chedington will fund and indemnify in respect of any challenge to joinder. We do not understand what other challenges in satellite litigation the trustees are concerned about. Please would you clarify what you have in mind by return so we can take instructions. There was no clarification for the hearing. As for Roman 4, we said we do not consider there's any risk of challenge for the breaks if the trustees are acting pursuant to the directions of the court. And that goes back to the submission I made this morning. Once the directions are given, the trustees have protection because they can say, you can't challenge us again under section 383 because we're acting pursuant to directions already given under section 383. As it was, the breaks turned up at the hearing and it's sufficient, so there would have been a collateral attack issue in any event. And then as for Roman 5, we confirm, and this was always the case, that Chedington's offer of funding, as set out in the draft undertaking, is not limited to legal expenses and time. So, my lord, we say that and it might be my fault, my lord, for taking that too quickly, but we do say that all of the matters raised in paragraph B 1 to 5 were addressed. C fell away at the hearing. This is on page 12, back in tab 1.
Mm-hmm.
It's pretty clear from the letter that was just sent that the indemnity was never on the table. That was a misunderstanding. D then refers to impartiality, independence and neutrality. And it's worth noting here that the point made is not by reference to other creditors, but rather that it's obvious that suspicions are rife as between the applicants and the breaks. That was how it was put below. The trustees didn't want to get trapped in a dispute between creditors and bankrupts, and that's one of the points that the judge is critical of, as we'll see.
Well, between applicants and the breaks, not creditors. Chedington are not creditors.
Well, put Chedington out of the mix. As it happened, Chedington's standing was not finally resolved below. First and second respondents are effectively a one-man band creditors committee. They're 60% approving creditors.
Sorry, can I be clear as to what you're saying there? I understand entirely what you're saying about Patley Wood and Mrs. Brown.
Yes.
But are you submitting that it is some way irrelevant that Chedington is an applicant? Is that the submission?
My lord, yes, that was effectively the decision made by the judge below from which there is no appeal. He says, I accept that the first and second respondents have standing as creditors because they're pursuing their legitimate interests as creditors. Right. I therefore don't need to decide whether Chedington has standing to make this application or not. The So the
Well,
application,
to be sure. So he didn't make any decision as to the standing of Chedington one way or the other. But is it irrelevant in your submission that one of the applicants before the court was Chedington?
yes, because it's
Why is that irrelevant?
Because it sufficed that only one of the applicants, in this case two, were found to have a legitimate interest in the relief sought, and so had standing to pursue the application.
Well, certainly, but that's not the point that's being made here. The point that's being made is that suspicions are rife between, and you can substitute Chedington for applicants, because that's where all the fuss is. It's this war of attrition between the Brakes and Chedington.
My lord, if only it were that, there is a long history of litigation between Mrs. Bream and Patley Wood Farm at the Brakes as well. And the whole point of the bankruptcy was that it was meant to provide a class remedy system. It hasn't got them anywhere. So I don't accept, with respect, that applicants there is really just referring to Chedington at all.
Certainly includes Chedington.
Yeah, it includes Chedington. But we say that's irrelevant once you're over the threshold of standing. Because what the trustees are saying is that they do not want to take a position as between creditors and bankrupts. And that's a finding, an evaluation of the position that the judge then reaches in the judgment. Now, D is obviously the focus of the appeal, and I'll address it in more detail in a moment. But just to see then how those submissions are dealt with by the judge very briefly, we go into the judgment itself. So put away the supplementary bundle and go to tab 5, page 54. Now the way this plugs in is that at paragraph 51, the judge notes that the trustees themselves accepted at the hearing that most of their funding concerns had been addressed by the letter from Stewart's, to which I took a court a short time ago. Then at paragraph 52, he dealt with the rest of those funding concerns, and we say that the reasoning there was entirely justified on the material available to the judge at the hearing, for reasons that I'll go into in more detail when addressing the grounds of appeal. And then at paragraph 54, the judge deals with the trustees' points about neutrality and independence. And just picking it up at equally unimpressive, that's at the top of page 55. It says equally unimpressive is the trustees' failure to appreciate that it is their job not to be neutral as between the creditors and the bankrupts. That's the finding that was made. They haven't appreciated their role. It's their job to advance the interest of the creditors against the bankrupts. The trustees may say they want to be neutral and impartial as between Chedington and the Brakes. It's the point that was just made by the court. But that is irrelevant to the question of what is in the best interest of the creditors. And then he goes on to deal with the independence point, describing it as simply absurd. And again, we say there was ample material before the judge below to support that evaluation. And so my lords, my lady, just before moving on to my third heading, go back to where I began on this heading, which is the finding of paragraph 50. We say the material available to the court showing that the trustees' reasons constantly shifted and no attempt by the creditors and Chedington to meet those concerns was ever good enough, justified the judge's evaluation of the position in paragraph 50. And if this court is not able to overturn the evaluation in paragraph 50, we say that should be logically the end of the appeal, because that is perversity. Now, I now move to my third heading, which is the grounds of appeal. And can I make 3 points at the outset about the shape of this appeal? That the first is, and I've already made the point really, that the finding of paragraph 50 was not appealed.
Was not?
Was not.
Appealed. Paragraph 50. The finding in paragraph 50 is not appealed. There's no ground of appeal saying the judge erred in finding that the trustees were striving at all costs to avoid litigation with the Brakes. We say that's important for the reasons I've already given. The second point about the shape of the appeal is that there is no appeal from the later judgment in order from December, the Section 375 application. Despite the submissions that my learned friend made this morning, and although I noted...
Well, where does that get us? The judge said on the 375 application, it's not a substitute for an appeal. You should appeal, and that's what they've done.
Correct, but in terms of that, there was some concern expressed from, I think, my Lord Justice Arnold this morning about the judge effectively telling the trustees what they could and could not say to this court on the eviction appeal. And the point I'm simply making is that's not within the scope of this appeal. It's something that happened after the order that was made below, and there was no appeal from the Section 375 application. And moreover, and this is important, the 375 application was not an application by my clients. It was an application made by the trustees in circumstances where they said they were unsure as to the position they should take. And so they went back to the court for guidance. So it wasn't the respondents to this appeal who put the court in that position. It was the trustees in bankruptcy who went to court to ask them for directions as to what to tell this court. They put the judge in that position, and we say that shouldn't be held against my client on this appeal, or indeed that it's at all relevant to the issues of this appeal. The third point is that we say that
it's a very strange decision, though, isn't it? I mean, you don't go to the court and say, Judge, please write my skeleton argument.
Well, it wasn't our application, but we responded to it saying it wasn't in the interest of creditors for the trust. I don't think the original draft written submissions are in the bundle. Effectively, what happened was the
I think they are somewhere. I think I've seen them. Maybe not in the appeal bundle, but maybe, we've got so many bundles arising out of this. I think I've seen them somewhere.
We can produce them if not. But the short point is that the trustees produced about 12 pages of submissions, 10 of which told the court of appeal why they didn't have a beneficial interest, and then 2 pages at the end said, but if you're against us on that, then we would like the relief we want to see.
But what I find puzzling, I mean, I understand the points you've made, but the judge's response wasn't to say, I've made an order, and it's up to you how you comply with it. On the contrary, the judge's response was to make an affirmative order requiring the trustees not to say some things and to say others. So I could understand your stance if the judge had simply said, no order, your duty is to comply with the order I've already made, that's the end of it. But that's not what he did.
Yes, I mean, I'm loath, given I'm conscious of the clock to get into it too much, but the point, the way it was put in December was that there was a conflict between the trustees' duty of candor to the court and their duty to comply with the directions that had already been given. And so they went to the judge and said, we think our duty of candor to the court requires us to make effectively 80% of our submissions on where we don't have a beneficial interest, and then say, if you're against us, then we'll have the relief we've been ordered to seek. And the position that the judge therefore had to take was to say, well, does the duty of candor require you to say that? And he said, no, you don't have to say that. You can legitimately point out that this is an issue in the insolvency proceedings, but the eviction proceedings are proceeding on the assumption that the contractual arrangements are valid and binding, because that was the finding I made at trial in eviction, and that bit of the eviction trial judgment was never appealed to this court. So that was the position in December. I accept that coming to it cold, it looks odd, but that was the way the argument unfolded, and the position that the creditors took at that hearing was that it wasn't in the interests of them for the trustees to be making the breaks arguments for, and that they could refer to that argument being there, but it wasn't for them to put in 80% of their submissions on why they didn't have a beneficial interest in an asset. And then that was the way it was resolved. So I hope that answers the question. But,
Thank you.
The third point on the scope or the shape of the appeal is that we say that there isn't a challenge to the upside points. By the upside points, I mean points A, B and C, paragraph 9 of the letter of the 9th of November.
Yeah.
When we get to ground 1.1, we'll see it's all about downside, not upside. And that's relevant given the way that my learned friend put it this this morning when dealing with the question of whether the bankruptcy estate was so underwater that there was no upside to the appeal. So that's not actually within the scope of the grounds of appeal that have been drafted. But let me just briefly deal, if I may, with the factual case before I think he took you to the core bundle, tab 7, page 195, which is a progress report.
Yes.
195 is the expenses, and I think you may have been taken also to 193, which deals with the trustees' time costs. But I'll be corrected if that's wrong. And I think the submission that I learned it read was that when you add up Mr. Swift's expenses of around 500,000, the trustees' expenses for this litigation of around 83,000, and legal fees of around 80,000, there was no possible upside. I made my submissions already about that not being actually.
No, I don't think that was the point that was being made. It wasn't there was no possible upside, there was no possible dividends to creditors, which is different.
So, my lord, well, no possible upside to creditors, can I put it that way?
All right, if you prefer that. There may be an upside to the bankruptcy estate,
Yes.
but there is no reasonable prospect of a dividend to creditors.
My lord, yes. And our primary submission on that is that that's a matter, it's returned to the estate that matters. If you're not with me on that, I then need to deal with the secondary point about upside to creditors on the other side of the insolvency process. Now, we say that the judge was entirely right to find below that there was absolutely no certainty as to which of these expenses would be allowed in due course. As to Mr. Swift's 500,000, his conduct is obviously
Well, wait a minute. I'm no doubt you're right to say the judge was entitled to find that there is no certainty that these fees would be allowed. Equally, there's no certainty there won't be. And if the trustee is taking a view, why should the trustee assume that a large portion of the fees will be disallowed as opposed to allowed?
Well, I think there are 2 points there. One, that wasn't the position taken below. They didn't say we accept there's uncertainty and so therefore we're going to proceed on that basis. They said to the judge below that one of the reasons why they were taking the position they were taking is because there was never any prospect of a return to creditors. So my lord's hypothesis is not the way that the trustees actually conducted their decision-making process. The second point is this, is that the gist of my learned friend's submissions, in effect, is to invite this court to overturn the judge's evaluation of paragraph 28 of the judgment. I think you were taken there in the context of standing, where the judge said that it was all up in the air in terms of where this all might end up financially in the conduct of the bankruptcies.
Well, the judge is dealing with this point in the context of who's entitled to make the application, not the merits of the decision under attack.
My lord, yes, but we say the point tracks across. Even if the judge doesn't expressly go back to the point, it's clearly got to mind. He's dealt with this in the judgment.
Sorry, say that again, I didn't hear.
Sorry, my lord. We say even if the judge doesn't expressly deal with it later on in the context of the merits,
He doesn't seem to.
He's got it in mind. He's dealt with it, and I believe on the last occasion I was before your lordship, I cited my lord's judgment in Volpe to that effect. And if necessary, I would repeat that submission now. Just because the judge doesn't refer to it later on, it doesn't mean that he failed to take it into account. It's reasonable to suppose if he's referred to it in the judgment as a whole, he hasn't excluded it.
But I'm a little puzzled by this, because the figures are the figures. I mean, of course, there is a question, and it might be a big question, as to what's allowable, which, as my lord has pointed out, will be for resolution hereafter and may go either way. But in terms of what the figures currently are, you don't dispute the actual figures, do you?
Well, there's, on legal expenses, there's a bit of context to give, which I'll give in a moment. There's a short answer to that, we say. The figures are the figures, but in terms of this point that I'm trying to meet, which is, will the creditors ever see anything out of these directions? A logical step in my submissions is not to challenge the figures, but to say whether those figures are going to be held against the creditors in due course. Does that make sense, my lord? Probably not.
Up to a point.
Up to a point. You may not accept the submission, but the submission is that even if the figures are the figures, the question about whether it has an economic impact on the directions given, if that is relevant, will turn on the extent to which these expenses are allowed. And so in that context, the court has to consider whether the judge's finding, paragraph 28, that this was all too uncertain, and so the court can assume one way or the other, should stand. And if I can just make that submission good.
Well, we're not looking at that, are we? We're looking at the trustee's decision. One of the reasons the trustees took the view they did was that there was unlikely to be any dividends to creditors.
Yes.
And as my lord says, the figures are the figures. Unless you can say in some way it was perverse for the trustees not to have discounted those figures to some other figure, that was a reason a view they were entitled to take, wasn't it?
The way I approach it in this court is that you effectively have to ask, was the judge right in his approach to the
do we?
figures, which is
Because
paragraph
the judge is not saying. The judge is not saying that the trustee's view was, as recorded in paragraph 28, was itself perverse. All he's saying is it may not be right. Well, of course it may not be right.
No, but if the court proceeds, as the court did below, that it couldn't make a decision one way or another as to whether these directions would ultimately result in a return to creditors in addition to a return to the estate. But that's the real issue. If the judge proceeded on that basis, and that informed, provided a foundation for everything that followed. And I think my learned friend is right about, be corrected if I'm wrong, is to say that the judge was wrong to take that approach, and you should have accepted the trustee's approach, which was to say it's very unlikely that there will ever be a return to creditors, and therefore their interests effectively don't come into it when it comes to the evaluation of whether we should intervene or not. That's the point I'm seeking to meet. And if I could just very briefly deal with the three limbs of the expenses. Most of them are Mr. Swift's. Mr. Swift's conduct is currently being impugned in the insolvency proceedings. If those proceedings are successful, that is going to have a material bearing on whether and to what extent his expenses are recoverable from the estate. As to the trustees in bankruptcy themselves, they have, before these proceedings, incurred around £83,000 in bankruptcy expenses, in circumstances where their stated position, from the moment they took over from Mr. Swift until this litigation, was that they should do absolutely nothing at all until the various break litigation was over. And so we say that, again, one can see in due course how creditors might question how £83,000 of expenses have been run up if you're adopting that approach. I'm not asking the court to determine any of this. I'm just setting out the case that we set out below, which informs what then went into paragraph 28 of the judgment. And then finally, as to legal fees, which were at £79,000 as at the date of this creditor's report, my learned friend took you to the asterisk beneath the table on page 195. He took you to the first sentence, which said that that related to both Mrs. Brake and Mr. Brake. But he didn't take you to the next sentence, which is, please note that the figures in the above expenses excludes billed legal time from the funding, capital F. That funding was £200,000, which the Brakes funded the trustees to undertake certain things. The evidence on that, if I can just show you briefly, is...
That funding figures in the accounts, isn't it?
It is. Can I just show you what that funding was said to be for? That is in Ms. Kick's witness statement from the application below.
Please could you tell me why it matters?
Why it matters?
Yes.
Well, the short point is this. Again, there's no clarity as to the terms of that funding and whether legal expenses are in or out. But the facts as they stand is that the breaks gave the trustees £200,000 and it's not clear whether they were to just use those expenses to do one thing, which was to investigate the conduct of Mr. Swift, or whether actually that funding was given without ties. And if so, if it was given without ties, which is what the court was told on instructions below, then there's a question mark about why a large chunk of those expenses are being excluded from the funding.
So you are questioning the figures. Before you said the figures are the figures.
The figures are the figures. It's a question about how you meet them. And in circumstances where the breaks gave £200,000 to the trustees, and there's a lack of clarity about the terms of that funding, there may be an argument in due course that the other legal expenses to which my learned friend drew your attention may be defrayed against the funding rather than defrayed against any realisations made in the estate.
I'm sorry, I'm not quite following this. The funding is shown in the accounts as essentially an asset of the estate, isn't it?
My lord may be ahead of me. Can I ask?
It's page 188 of the court.
Yes, 188. Right, so that's a realisation.
Yes.
Set against that are the debts. So if part of the 200,000 is transferred in order to meet the legal costs, it just increases the gap between the realisations and the debt by an equivalent amount. So it makes no difference.
My lord, I accept that point. Let me move on. So those are my submissions on the scope of the appeal. If I can deal with what we say is within the shape of the scope of the appeal next. Ground 1.1 is the challenge to the judge's evaluation that there's limited downside, just a downside from intervention in the eviction proceedings. The exact phrase used by the judge, and this is at paragraph 52, is that it was difficult to see the downside. So it wasn't a finding that there was no possibility of downside. And the respondents in my submission did not need to show that this was a risk-free strategy for realising value from the estate, but only that it was sufficiently low risk compared to upside and the relevant alternatives that it was perverse not to pursue it.
Yeah.
And that's consistent with observations made by Mr. Justice Snowden as he then was in Longmead. Given the time, I won't take the court to it now, but just to give you the reference, if I may.
It was in the notes to section 305.
What was that? Sorry, my lord?
It was in the notes to section 305, which you showed us this morning.
It was in the notes, in the Moor Hunter. Exactly. Office holders aren't expected to take a risk-free approach. And we say that's apposite when it comes to ground point 1.1 of the appeal, because the trustees can't raise the risk of some loss, however speculative, as a complete answer for not taking the steps to realise value from an asset in the bankruptcy estate. And one needs to consider in this context not just the upside, which isn't challenged, but the relevant alternative, which was a major focus of the hearing below. The relevant alternative to the trustees taking this step and possibly being able to put Chedington or someone else paying a licence fee into the cottage is that the breaks go back into the cottage, paying no money at all to the estate, with the risk, given their previous conduct, that they will refuse to leave, necessitating expensive proceedings, and with the risks that the breaks of occupation of the cottage would pose to its capital value, including its maintenance and upkeep, given the claims of impecuniosity.
Well, this is where I get a bit lost. I quite accept that the relevant alternative may be something the judge can, perhaps should consider. But what I don't understand is why, amongst the relative alternatives, are the various options that were canvassed after the judge gave judgment, including selling the beneficial interest and selling the cause of action.
My Lord, as a matter of fact, that wasn't raised before the judge. It wasn't part of the direction sought. I've taken my Lord to the open correspondence on that. I don't think.
I mean, the way that was chosen seems to be the messiest of all possible outcomes.
Well, my Lord, it may not be the best of outcomes, in the sense that my Lord has suggested that a cleaner outcome would have been a sale. But it's not the worst in our submission, the worst outcome. And therefore the relevant alternative was the brakes going back in, with no benefit to the estate whatsoever, and the risks that posed for other realisations that may be made in respect to the bankruptcy's sole or principal asset in due course. Now, we say the question in every case is whether the refusal to take the risk is perverse. That's obviously fact sensitive, can't be generalised. But at some point, the risk becomes sufficiently small or manageable that it becomes perverse to refuse to take it, given what may happen if you don't take it. Now, ground 1.1 itself falls into two parts. If I can just briefly address the first, which is ground 1.1.1.
Sorry, if we're going to go through them in granular detail, I need to have them open.
Sorry,
Right, 1.11, yes.
Yes, it's at page 15 of the...
Yep, got it.
Great. This is the concern about potentially protracted, time-consuming and expensive litigation. And one might get the impression from my learned friend Lewison argument, and indeed the way he opened the appeal this morning, that the trustees were being directed to intervene and participate in the break litigation generally or in some open-ended way. And we say that's a straw man argument, that trustees were directed to intervene in a single ground of a single appeal. And certainly the bankrupt's litigiousness, because this litigation Chedington has been the defendant in everything other than the possession proceedings where it was seeking to get back its property. The break's aggressiveness should be treated with some caution, given trustees in bankruptcy are meant to adopt a fairly robust approach to bankrupts. And that was the point made by the judge.
So, is it your submission that it is irrelevant and therefore perverse for the trustees to take into account that they're going to be in litigation with litigants who you yourself describe as aggressive and who the track record shows will appeal anything that can be appealed and plenty that can't be?
My Lord, no. I'm not saying it's irrelevant as a factor, but it has to be balanced against everything else, and this is ultimately fact sensitive. I'm not saying it has to be excluded at all. It's something the trustees can take into account. What is perverse is when you strive at all costs, therefore, to engage in litigation with the bankrupts, regardless of the considerations. Now, my learned friend developed this point in his supplemental note, which purports to update this court on recent developments in the eviction proceedings since the hearing below. Now,
Well, this is 1.1.2 now, are we?
no, we're still within 1.1.1.
Oh, right.
So in developing his submissions on 1.1.1, my learned friend's supplemental note says that the concerns about how time-consuming this litigation is going to be has been borne out by subsequent events. Now, as a matter of principle, we say that that shouldn't be taken into account in this appeal, because this is a review, not a rehearing, and the court is considering what material was before the judge below, rather than exercising its discretion afresh. And even if those directions constituted a material change of circumstance, the remedy would be to make a Section 375 application rather than to raise it in the course of this appeal from the original directions. But just dealing with the substance
Well,
of
I'm not sure
the
about that. If you submit to a first instance judge, there is this danger looming. And the first instance judge says, no, it's absurd, there's no such danger. And then the danger happens. Why can't you say, well, look, I told the judge there was this danger. Now it's happened. You can see he was wrong to say, to dismiss it.
But for the reasons I've given, that this was an evaluation of the material that the exercise for this court is to look at the materials that were available to the judge below. And that obviously doesn't include the things that have happened in compliance with the directions given below. That's the submission as to why you shouldn't consider any of it. But if you were to do so, we say there is something of an overstatement when it comes to the complexity of what's now going on in the eviction proceedings. I am not asking, as I said this morning, for any sort of preliminary view on what is going on, but simply actually what has happened. First, on the joinder application, my learned friend said, and this was at paragraph 4 of their supplemental note, call bundle 12, page 376, there's no need to tell it out.
Yeah.
That the breaks have advanced no fewer than 14 preliminary objections to joinder, many of which are said to be novel. Now, those objections are found in the supplementary bundle at tab 61, page 255. Beginning at page 259. I'm not going to go through the details.
No.
But I would say that the number 14 isn't because there are 14 grounds of objection, it's because there are 14 subparagraphs of paragraph 11, which runs to page 262. So that's not the same as 14 preliminary objections, it's a series of submissions developed over 14 paragraphs. And far from those points being novel, we say that those objections could fairly be characterised as an orthodox argument about the application of CPR 19.2. Nothing else the ordinary, and the trustee's legal opinion should be sufficiently robust to be prepared to deal with litigious bankrupts who are prepared to have an argument about the application of CPR 19.2. It doesn't take the appeal out, what's happened since, out of the ordinary. The joinder application may require a hearing, but it will be a hearing measured in hours, not days. Nothing especially onerous, and it would not justify reopening the decision given below. As to the second point made by my learned friend, this is in his supplementary note, just for your note, it's paragraph 6, which is on page 376. He submits that the proceedings in the eviction appeal have already been protracted and time-consuming since the directions given below. And with respect, that's a bootstraps point. What has made the intervention protracted and time-consuming and more expensive is this appeal. And the irony is that if the trustees had not made this appeal, the eviction appeal might have been heard at when the directions hearing was listed, or it might be heard today. It's only been delayed because of this appeal. And so we say there's nothing in that. And the limited nature of what was required by the trustees is obvious from the application itself. I can just go very briefly to that. That's in the supplementary bundle, tab 72, I believe. And one has the application notice at pages 282 through to 285. And then the written submissions run to around 5 pages, beginning on page 286. And the meat of the application begins on page 289. The headings on the foot of the previous page, order for possession, where the trustees make their Talata application. And then at paragraph 8, there's the Saunders and Vautier point.
Yeah.
And then over the page, 290, is the conclusion. So it's a page of written submissions that the meat of the argument. So it's been very straightforward. We say try to handle, and indeed it was striking. And these are in the grounds of appeal as quoted in the judgment below. But what's been done is exactly what Mr. Learmonth canvassed with this court as what should have been done by Mr. Swift. He said that Mr. Swift should either have applied under Talata or he should have applied to exercise the Saunders and Vautier rights. And the complaint in the eviction of it is he didn't seek an order on either basis. So not complex, try to handle, we say. So that's the first part of ground 1.1.1. That is ground 1.1.1. Dealing with the second part, that's 1.1.2. This is the prospect of a dispute with Chedington about whether the fees incurred in intervening would be reasonable or not. Now, I deal with this at paragraphs 49 to 54 of my skeleton, and given the time, I'll just take this quite lightly if I may. We say it's perfectly normal for an indemnity of this nature to be limited to reasonable costs. No reasonable third-party funder of an office holder claim would agree to meet unreasonable costs or write a blank cheque. And so the risk to which the office holders were exposed or are exposed in these proceedings is no different to the risk which office holders take day in, day out when relying on third parties to pursue their claims. It's not the type of risk which is a roadblock to pursuing an asset in litigation for the benefit of the bankruptcy estates. Now, if there is a dispute, and that's something for the future, it will be resolved relatively straightforward. As my learned friend said in the skeleton argument, those sorts of disputes are resolved by the court day in, day out, up and down the country, as to what are reasonable costs or not. It will be a lot less expensive and a lot less time-consuming than this appeal. It's going to be an hour, probably, in front of a judge at first instance. And certainly the bomb shelter principle that my learned friends rely on doesn't come into it. It's not an application of directions. It's an application about what's reasonable in reference to the undertaking. So we say that case law on bomb shelter just is simply irrelevant. Now, in my learned friend's supplementary notes, some rather heavy weather is made of what's happened since the appeal. And you already have my submission, so you can't take that. You shouldn't take that into account. You can't as presumptive, so shouldn't say that, but shouldn't. But in any event, the substance of what my learned friend set out in his supplementary note is incomplete. And can I just draw your attention briefly to a letter sent by my solicitors, which is in the supplementary bundle, tab 70.
70.
70.
Yes, 5th of July.
Correct. And within that,
Sorry, could you give me the page?
I'm so sorry, my lord.
278.
Thank you.
My Lord Justice Lewison's ahead of me. And you will see at paragraph 2 a chronology. I'm not going to go through the detail of that now, save to identify 2 points. The first is that in the letter of the 21st of April, the trustees claimed that the step of filing an application notice, the 5-page written submissions, which I've taken to the court, and the effectively one-page witness statement, which I took to court this morning, have cost the trustees £71,000. And it's entirely reasonable in those circumstances for any third-party funder to ask for a breakdown. And that's what's been asked for. That breakdown only came very recently. You'll see
The 14th of April, wait a minute, the directions hearing before us was in May. But before that, there had been the application back to Judge Matthews with clarification about what they could and couldn't say.
Yes, they say that's outside this.
That's outside.
They paid our costs for that. They were unsuccessful. So I agree, it includes the directions hearing as well, to the extent that the costs of that direction hearing are incurred by the eviction appeal, by this appeal. So there may be a conversation about, and one of the questions we've asked and we've not had an answer to is when counsel's time for that direction hearing has been billed to Chedington, we've asked, this looks high, have you applied a 50-50 split as between this appeal and that appeal, because the directions hearing was to manage both, and we've not had an answer to that.
Yeah, right.
But the short point is that having raised the questions about why £71,000 had been incurred before the directions hearing, even at letter J in this chronology, 7th of June, about 6 or 7 weeks ago, we still haven't been given a breakdown. That breakdown only came on Friday evening, last week. And so for my learned friend to complain that it was only this week, on Tuesday, that Chedington offered to pay money on account of £30,000, we say lies ill in the mouth of the trustee in circumstances where they only gave us a breakdown, as any third-party trustee, funder would, at the end of last week.
Yeah.
My Lord, that's everything I wanted to say on ground 1.1. Can I deal briefly with ground 1.2? And can I start with the trustee's evidence on this before the judge below, to which you were not taken by my learned friend this morning? That is in the core bundle, tab 8, at page 248. Paragraph 34. The trustees say that their two principal concerns with the indemnity offered are as follows, and then over the page. One, how this would be perceived by third parties, including the breaks, whether this would be used as a basis for criticising the joint trustees' conduct. And secondly, the risk that an indemnity would give Chedington potential leverage or possible control over the joint trustees in the cottage eviction proceedings. Now, starting with the perception point, I made the point this morning when opening the respondent's case on the appeal that no creditor has ever come forward, below or since, to raise concerns about the funding arrangements. There was no evidence before the judge below, or indeed on this appeal, that any creditor has a perception problem with this. And indeed, given that the funding arrangements are formally embodied in an undertaking to a court order, we would say that no reasonable creditor should have a problem with it. The only third parties identified in the evidence, before the judge below, were the breaks themselves. That's developed to paragraph 35 of Miss Kick's statement. It doesn't refer to creditors at all. It's all about the breaks. And that's the material the judge was referring back to in his judgment when he said that the trustees had got themselves into a complete mess about neutrality between creditors and the breaks rather than independence. And the impression one gets from this evidence, and indeed the submissions as then developed before the judge below, that it was the trustees' overriding concern to avoid criticism from or litigation with the breaks. That was the evidence before the judge. And indeed, that was how it was put in paragraph 16b of the skeleton argument, which I went to a short time ago. The only references to challenges were to challenges by the breaks, not by other creditors. And we say that is fundamental to what the judge then found. They misunderstood their duties, the trustees, in thinking that they needed to be neutral as between the breaks and the creditors. That was the finding of the judge below. We say that meets the perversity threshold. There's no challenge to that on this appeal, and we say there was ample material in any event to support that finding. So that's the perception point. As to the question of Chedington controlling the trustees through the indemnity, the judge was right to dismiss this as simply absurd. The steps that the trustees are to take are exhaustively prescribed in the order under appeal. Can I just go there very briefly? That's core bundle tab 4, page 26. Sorry, page, and the body of the order is actually on page 27. Now, paragraph 1 of that order has already been complied with. No risk to the trustees' independence has been identified in complying with paragraph 1. If there is a hearing under paragraph 2, then counsel instructed by the trustees will prepare for it and attend it in the usual way. Again, no risk to independence. The trustees are clearly capable robust counsel to represent their own interests in the Court of Appeal. If that intervention is unsuccessful, that's the end of it. But if the trustees obtain permission, having complied with steps 1 and 2, then they'll need to see whether they can get a better price than the price offered by Chedington, and and the trustees are entirely independent and free to accept a higher bid than that put forward by Chedington. So the trustees remain independent under paragraph 3. Now that can be contrasted with the position in Bakari, which is one of the authorities that Management relies upon in this context. That's in the authorities bundle, tab 7.
Yes, that's when the trustee agreed he'd follow the bank's instructions and wouldn't compromise without the bank's approval and so forth.
My lord's got the point. You can just very briefly look at it. It's page 103 behind tab 7. And it's in my submission, clear from the fact that Lord Justice Robert Walker's then was quoted in full clauses 4 and 5. Those were the offending provisions that led him to consider that some sort of characterisation of hired gun was appropriate in the case. And indeed over the page 104, he says, a serious question arises as to whether the arrangement embodied in this deed does not involve a questionable delegation, if not abnegation of powers. Abnegation of powers is right here. The directions under challenge do not have anything like clauses 4 and 5 in them. And if we had sought directions for such control, which we did not, no doubt they would have been refused. So we say Bakari is entirely distinguishable from this case. Now, as for re-NG or re-in, that's at authorities tab 6. In that case, the trustees were seeking an order for sale of a property which was subject to a charge in favour of Bradford and Bingley Building Society. And as the judge notes on page 98 of the report, between C and D, there was no value in the equity of redemption, which was the only asset in the bankruptcy estate. No value because the proceeds of sale of the property would all go to the secured creditor, namely the Building Society. And so the only value to the estate from this arrangement was not any step in realising value from bankruptcy assets, but rather the trustee charging out his services to the Building Society. And one can see that from the reference to services on page 99 at H.
H, you say?
At H.
Yeah.
Towards the bottom of the page, where he says, the society should not be able to seek to save its name, face or feelings by buying the services of the trustee. That's important. Because this case is different. My clients, the first and second respondents, agreed to lift the charge on the cottage if sold to Chedington. So in terms of the directions insofar as they concern the capital value of the cottage, it's realising value from a bankruptcy asset, not from services that the trustees are rendering. And in any event, the charge does not prevent the trustees from realising value from the possession of the cottage.
The offer to release the charge,
Yes.
remind me if this is wrong, I thought was only if a sale goes through to Chedington.
It's expressed in those terms. The choice being offered to Mrs. Bream at the time that she made that offer was...
and that would be the agreed sale at $500,000.
It would. As
So,
to whether,
there would, on that basis, be
Yes.
no capital appreciation that accrued to the bankruptcy estate.
yes, but in terms of protecting the capital value to preserve the contract that's currently in place, I accept there may be a debate about the long stop date in due course, but you've got the terms, and we say it doesn't affect the validity of the contract, it's about questions of waiver in due course. The fact that the charge has been lifted means that insofar as the directions are intended to preserve the capital value of the cottage, it's directed at a bankruptcy asset.
Well,
It's not about the service.
is that right? It's directed to preserve, the lifting of a charge is directed to preserve the capital value of the cottage for Chedington, not the bankruptcy estate.
Well,
Because the lifting of the charge is conditional on the sale to Chedington going through.
My lord, we say it's both. It's both. It makes it a bankruptcy. All I'm saying is by lifting the charge, it becomes a bankruptcy asset. And therefore, it's not a case of just using the trustee's services by reference to something that isn't a bankruptcy asset. Right. Put another way, what the trustee was doing was not within the scope of Section 3052 of the Insolvency Act. It wasn't taking reasonable steps to realise value from bankruptcy assets. It's all about using services to do something that's got nothing to do with realising value from bankruptcy assets. That's the point I made at paragraph 62.2, my skeleton argument, and we say that point also acts as a further basis for distinguishing Bukhari if it's needed in addition to the points I made about clauses 5 and 6. And the broader point, and this is my final submission on ground 1.2, maybe really to hear in the appeal as a whole, is that it doesn't matter where the funding comes from. It doesn't matter. It can be from the creditors, it can be from the bankrupts themselves, as happened with the Brits. It could be from a commercial counterparty, like Chedington. It could be from a specialist insolvency litigation funder like Manolete, as in Eden. I'm going to get my Eden note and Edengate muddled up, but the more recent of those. Funding per se does not compromise independence. It does not make trustees hired guns. So the funding itself does not matter. What matters are the terms of the funding and what the trustees are meant to do with that funding. And the trustees would only be falling within the scope of the criticism made by Mr. Justice Lightman about being a hired gun if they were doing something that was not in discharge of their duties. Yeah. And there is no suggestion in this appeal that by complying with the directions, the trustees would be doing something that wasn't in discharge with their duties, as was the case in Re-Ing. In this case, the terms of the funding are transparent, set up fully. Funding is available to enable the trustees to take reasonable steps to realise value in the bankruptcy assets. It doesn't involve them compromising their duties as office holders or acting as a hired gun. It so happens that their duties align with the interests of Chedington. But an alignment of interests doesn't make funding arrangements improper. That happens all the time. That's why commercial funders get involved, because they want to line up their interests with the office holder and share the proceeds. An alignment of interest in a funding arrangement where there's no compromise of duties does not fall within the scope of the criticisms that were made in Re-Ing and repeated in Bukhari. My lords, my lady, you've been very patient with me. Subject to any further questions that you may have, those are my submissions.
Thank you very much, Mr. Day. Mr. Westwood, do you wish to reply?
My lord, I'll be very brief if I may. Just a small number of points. Just on an issue was raised about funding, and this reference was made to £200,000 funding in the context of figures. Can I just feel the court's note? Lord, this is also dealt with and addressed in the progress report that we saw earlier, where the figures come from, and that's page 216 in the core bundle. And the court will see there's reference to that funding arrangement. And in particular, at the foot of page 216, you'll see it being stated that the funding was provided without specific terms attached. So that funding of £200,000 came with no specific terms attached to it.
Yeah.
Well, that was obviously in evidence before the judge, and that wasn't challenged before the judge. Well, the criticism of an ever-changing presentation of the trustee's case, in my submission, that is not a fair summary of the way it's put. But importantly for these purposes, the position was clear on any view, whatever view one takes about a development or evolution of the position in correspondence. The position was clear before the judge when the matter came before him for hearing. The position was clearly set out in Miss Kicks's witness statement. And the Lords and my Lady have seen that, and that's in core bundle at page 240. In particular, 240, that starts, my Lord. 240.
Yeah.
In particular at 242, where the headline point is made in paragraph 11, that the position has, that they've adopted a neutral position in relation to various court proceedings, and then explained why. This is because we're of the view that it is not in the bankruptcy estate's interests for us to be involved, as no substantive benefit is likely to accrue to the estates by us doing so. So that's the fundamental point. And then that's developed over the various subparagraphs in paragraph 12 and over the following paragraphs in that statement. And that position was also reflected in Ms. Page's skeleton argument before the judge. So whatever the position beforehand, the position when it came before the judge, and the judge himself accepted, as the Lord Justice Arnold pointed out, that he should determine the matter by reference to the position as it appeared when the matter was before him, the position was clear in our submission. And the other point to make in relation to that, my lords, my lady, is this, that you may recall this morning that I took you to the passage from Lord Justice Mayall's judgment in Edengate, where Lord Justice Mayall's made the point that it's an objective test. And indeed, Lord Justice Mayall's point there was that even if there was a trustee or an office holder had made a point, had advanced a reason that wasn't a good reason, if there was a good reason at the time of the hearing, then that was sufficient to defeat a perversity test. Lord, I was slightly concerned to hear some of my learned friend's submissions that got, in my submission, very close to an allegation of bad faith against Ms. Kicks and Mr. Nimmo. And that's a cause of some concern, because there has never been any suggestion before that this was a case where there was any question of bad faith or any improper conduct other than perversity. And my lords, my lady, can I just show you the transcript of the hearing before the judge? Because this point came up before the judge, and this is in the supplemental bundle. At page 30 is the first reference. And this is my learned friend's submissions to the judge. And my learned friend is taking the judge to the test under 303. And then if one can pick up the transcript at line 14, my learned friend says this: to be clear, the applicants do not allege that bad faith or fraudulence to the respondents. So we accept that to grant this relief, the court has to be satisfied the trustee's acts of perversity in the sense no reasonable trustee would have acted in this way. Well, the judge then comes to the question of bad faith on page 55. And this is my learned friend Miss Page's submission. And the judge makes the point at line 3, where the judge says, well, there's no allegation of bad faith. Miss Page says, no, there is not. And then the final reference, my lord, again, is in my learned friend's submissions. If the court could please go on to page 99. My learned friend is keen to emphasise that he is not advancing a case of bad faith. Page 99, line 18. See, my learned friend, if I could just invite you to read through to the 4 lines through to 21, in particular lines 20 and 21. So my learned friend is emphasising to the judge that there is no allegation of bad faith or fraud on the part of the trustees. And my submission is absolutely right. Of course, there was no application to cross-examine Ms. Kicks on any of her evidence before the judge, and the judge heard no oral evidence from her. Well, the point was made, I think, in relation to the judge's judgment in December, 16th of December, where the judge made the point about, well, Mr. Calland comes to me and tells me that these submissions and the request for directions as to whether or not the trustees can put matters before this court, the Court of Appeal, have arisen because the trustees consulted him after the order of the 25th of November. Mr. Calland said, they consulted me, I raised some concerns about whether or not the trustees could properly come before this court and at least not advert to the potential issues on title. And although the judge accepts that on the one hand, he does then, in a sense, slightly row back from that and say that in any event, this seems to me just to typify the view he's taken of what the trustees are doing. And my learned friend, in response to my Lord Justice Arnold's point, said, well, if in fact this court characterises that as a finding of bad faith, I think my learned friend said that he would adopt that finding or something to that effect. In my submission, my lady, that isn't a course that's open, and you shouldn't entertain such a course on this appeal. There was no, the case below wasn't put on the basis of bad faith. There was no finding of bad faith and no basis for that. My Lord Justice Lewison, you raised the question of the December application. I don't think it's one of the few documents we don't have in the bundles, my Lord. Perhaps if we've got a copy of the application and the draft submissions that were put before the judge on that application, and I wonder if we can provide those to the court after this hearing.
I'm almost sure I've seen them somewhere.
Well, my Lord, where your Lordship might have seen it, of course, is in the break submissions, reply submissions on the eviction appeal.
Yes.
They pick up some of the
They
points.
do, and they say that even though trustees can't advance it, they can,
my
and
Lord,
they do.
Quite so, quite so. And those submissions
You
are
had seen it somewhere.
in the bundle, my Lord. And although they're not identical, they inevitably pick up on certain of the points. So, but we'll provide those, if we may, after the course of the hearing. My Lord, just on, I don't, and I think this is my final point, and I don't want to get into in this court into details of the disagreements that there have been about reasonableness of costs or otherwise between those instructing me and Stuart. Well, but because my learned friend made a point about the correspondence, I'll just say this, that in December 2022, and this was the 5th of December 2022, in relation to Mr. Callan's costs, and I think I touched on this point earlier in the appeal, and this is page 197 of the supplemental bundle. The short point I was making was this. This was as long ago as the 5th of December.
Sorry,
And it starts at 196, and the particular point of what is on 197. Is this, that points were taken about whether it was reasonable or not to instruct Miss Page along with Mr. Calland. But the paragraph 4 on 197, you'll see that Stuarts accept that they consider that the proposed fee for Mr. Calland was prima facie reasonable. And yet, until Tuesday of this week, there was no offer to pay anything, even though it was accepted that it was prima facie reasonable. And it would have been open in our submission for them to say, well, we don't accept the others are reasonable, we accept that as reasonable, and therefore you can have that. Well, unless there's anything further I can assist you with, those were my submissions and reply.
Thank you very much. We will just retire for a couple of minutes to see where we are, so please don't leave the court.
All right.
Well, Mr. Westwood and Mr. Day, thank you very much for your arguments. It's late in the term, but we can tell you that we are going to allow this appeal with written reasons to follow. And we hope that there is a possibility that you will get the reasons on the last day of term. Right, put it no higher than that. Thank you very much.